Good afternoon, and welcome everyone that has joined us so far to the Epilepsy Foundation of Connecticut Fall Webinar Series. Today's topic is on special needs planning. For everyone's information, you all will be in listen-only mode throughout the course of this webinar. So please type any questions that you have in the question section at the bottom of your webinar screen, and they will be answered at the end of the presentation. If for some reason you cannot hear us or you're having some technical difficulty, go ahead and type the questions in the box, and I will respond to you during the webinar. So I would now like to introduce our speaker for today, who is Kathleen D. Tetreault, and she is a lawyer with Disability Planning Partners. Early on in Kathleen's career, she served as a special education attorney advocating for the rights of students with disabilities within the school system, and later expanded her passion for disability planning into the realm of elder law and estate planning. She is an active member of the elder law section of the Connecticut Bar Association and serves as the co-chair of the elder law committee through the Young Lawyers section. Kathleen co-founded Disability Planning Partners in 2017, just a few months ago, where she seeks to help individuals of all ages and levels of need to respond to present challenges, prepare for future needs, and to rest more readily with a newfound peace of mind. And so we welcome Kathleen to our webinar today.
Thank you very much for having me. So I was telling Monica that it's a pleasure for me to be presenting to all of you today. Although I can't see you, this is my first time doing a webinar, though not my first time doing a presentation on planning with public benefits. So it's a nice opportunity for me, and I'm looking forward to the journey with you. And as Monica said, I'm happy to answer any of your questions. Just type them in, and at the end of the presentation, I'd be happy to go back to any specific slides if you find that they'll help with the context of your question. So without further ado, the presentation I've entitled Planning with Public Benefits. And within my practice, I work with individuals with a variety of disabilities, epilepsy being among them. And epilepsy, I don't need to tell you, is unique to the extent that it does not have one set pattern for individuals. So some people with epilepsy can work and maybe don't need to rely upon different public benefits and supports, and others maybe can't work or have intermittent periods of being able to work. And some individuals have coexisting disabilities with epilepsy, which will color whatever their needs may be. So with respect to public benefit planning, the idea is that there are different public benefits available for individuals with disabilities that vary depending upon the level of need. So throughout my presentation, I'm going to start off with what are public benefits, and I'm going to go over then supplemental security income, Social Security disability insurance, and Medicaid supports, which are all types of public benefits that are available, but they might not be available to everybody because it depends upon what the individual's particular needs are. And then I'm going to conclude the second part of the presentation with an overview of special needs trusts and ABLE accounts. So first, I think it's important to say, well, what are public benefits? So public benefits are supports and services that are provided by either the state or the federal government for people with disabilities. So these programs can come in really two forms that we're going to talk about today. The first is a cash benefit. So that's money that an individual with a disability is receiving. And when I talk about cash benefits, I'm really going to be talking about Supplemental Security Income, SSI, and Social Security Disability Insurance, which is SSDI. And then some public benefits provide supports and services. So then, once again, as I mentioned, when people have different needs, the different public benefit programs and services that are available are tailored to those needs. So most programs, most of these public benefit programs, require that individuals meet low financial limits in order to be eligible. So one of the things that I view as almost a mission of sorts is to be able to demystify the fact that you can't have money and qualify for public benefits and supports. It's a total myth, and it's something that individuals don't know, not for lack of trying. I think it's a maze and a labyrinth out there, and then there's also a lot of misinformation that's provided. So the key here, as you see at the bottom of this slide, is that special needs trusts and or ABLE accounts operate to make money invisible, so that somebody could have well above and beyond what the financial limits of a program are and still qualify for that program. So you'll see that how a special needs trust and an ABLE account are powerful. And I want you to bear that in mind, that as I go through these slides and I talk about eligibility limits, don't tune out and think, well, I'm above that limit. That really wouldn't apply to me, because that's where special needs trusts and ABLE accounts really kick in and have their power. So the first benefit I want to talk about is supplemental security income. That's SSI. So a lot of people think of Social Security as this thing that applies for people who, let's say, are retired or who have worked. But there's really two forms of Social Security that are tailored specifically for people with disabilities. And supplemental security income, let's first start by defining, well, what is it? I mentioned earlier that public benefits can come in the form of cash payments. So supplemental security income is a monthly cash benefit for eligible individuals with disabilities. If an individual is eligible, they can receive up to a check of $735 a month, and that will go up as of January to $750 a month. The government, it's a federal benefit, so the federal government, they don't care what the individual spends it on as long as it's for them and their personal needs. But I think it's interesting and helps to understand the rules a little better to know that this program, from its inception, was based on the idea that people were going to use $735 a month to meet both their rent and food needs, which of course is laughable. Nobody could spend $735 a month and cover their rent, their food, and any other ancillary expenses they have. But I mention this because the government says, okay, if we think that you're using this benefit for your rent and for your food, then if you're receiving rent for free or you're receiving food for free, meaning, for example, somebody who's 20 years old and lives at home with their parents and doesn't pay rent and doesn't pay for their food, then Social Security is going to reduce their benefit, because in Social Security's mind, that benefit is really earmarked for food and shelter, even though you can spend it how you want. So if you're receiving that from somebody else, we're going to reduce your benefit by 1/3, which is to about $490 a month. So who is eligible for SSI? There is a two-pronged test. So the first prong is based upon an individual's disability. So Social Security defines disability as the inability to engage in substantial gainful activity due to a medical impairment that is expected to last 12 months or more or result in death. So Social Security says substantial gainful activity is somebody who is earning above and beyond $1,170 a month as of 2017. So that's about $14,000 a year. So Social Security is saying if you have some sort of disability that makes it difficult for you to earn this amount of money, then because it's impacting your ability to work, you have a disability, meaning you can have a cash benefit, which is essentially supplementing what wages would have provided to you were you able to work. So first, you have to have a disability based on Social Security standards. And second, you have to have resources or money of less than $2,000. So although an individual can qualify for SSI under the age of 18, so there's child listings, or the Social Security has a set of how somebody can meet a disability definition. while an individual can meet the definition under the age of 18, it's very difficult generally for people to qualify because the assets, the resources of parents are deemed or counted as part of the child's resources. So it's very difficult for a child, generally speaking, to qualify for SSI under 18. When that individual turns 18, however, even if they're, say, for example, living with a parent, they then have resources of their own. Their money is separate from their parents. So at that time, typically people will apply for SSI and have a much easier time qualifying for the resource limit. So I have a couple case studies here which I'm hopeful will really demonstrate how SSI works and what the rules are. So we have Grace, who's an 18-year-old young woman who has epilepsy. And due to epilepsy, Grace is not able to earn more than $11.70 a month, which we're really saying Social Security says she has a disability. So yes, she meets the first of our two-pronged test. Now Grace has $100 in a checking account and she applies for SSI. Does she have resources less than $2,000? Yes, she only has $100, so her application is granted. Now, her application is granted, but how much does she get? Well, Grace lives at home with her parents. She doesn't pay rent. She doesn't buy her food. So she's eligible to receive SSI, but she's not going to get that full $735 amount. She's only going to get $490 a month because her benefit was reduced by a third because she was receiving essentially free room and board. And lastly, let's say Grace is an 18-year-old young woman. She has epilepsy. She satisfies the disability definition for Social Security, but she has $5,000 in a checking account. So she applies for SSI and she's denied. Why? Because she has $5,000 and Social Security says you can't have more than $2,000. So I want to say we're going to come back to Grace for two reasons, and this is at the very end of the presentation, so try to tuck this example into the pocket of your mind. Because with proper legal planning, Grace can have unlimited resources. She can have $1 million, say for example, in a special needs trust, and still qualify for SSI, and she can use a rental agreement of sorts to get that full $735 a month. And later on, I'm going to explain the mechanics of that and how it works in practical effect. All right, so we're moving on to Social Security disability insurance. This is the second of the public benefits that we're talking about today. So what is Social Security disability insurance, or SSDI? Well, this benefit is not based on your resources. So you can have, as in that last example, Grace had $5,000 in her checking account. She could still qualify for SSDI with that $5,000 in her account, because for this benefit, it doesn't matter how much money you have. Really here we're looking at the disability status of an individual. And I say an individual because there's two ways to get this Social Security disability insurance benefit. And the disability focus we're talking not necessarily about the same person as to who has the disability in each instance. So let me explain what I mean. There's two ways somebody can get SSDI. The first is based upon the individual's own work history. So that means the individual has worked and earned enough work credits by working for a certain number of years before a disability has impacted their life and they're no longer able to work. So work credits, generally speaking, for every year you work and pay into Social Security, you earn 4 credits a year. So in my example, if a 35-year-old woman has worked for 10 years, she has a total of 40 work credits, which is 4 per year. When she can no longer work because she has a disability, she's eligible for SSDI because she earned at least 20 work credits in the past 5 years, which is the rule for somebody who is 35. So what I've provided here is a link to work credit resource, which will show you, based upon an individual's age, how many work credits do they need to get this Social Security benefit. Now, the benefit depends upon the individual's work history, and the amount is based upon a portion of that individual's earnings through their work history. So that's one way to get SSDI. The second way is through the Disabled Adult Child Benefit Rule. So this is the name of the benefit, the Disabled Adult Child through Social Security. It's a cash benefit for a child who has a disability that onset before the age of 22. Here, for this way, this doorway into Social Security disability insurance, the individual with a disability is not the individual who worked, which is really critical for a lot of individuals, especially my clients, because they haven't been able to work due to a disability. So it's important for individuals to know that you can get this benefit without having worked, as long as your parent has worked and one of three circumstances has arisen. So the first circumstance would be that a parent who has worked and paid into Social Security retires. The second would be that parent worked and then became disabled, as in the first example, or my prior slide, or that parent that worked has passed away. So in those circumstances, a child with a disability that started before the age of 22 can receive half of a retired parent's benefit when the parent starts drawing upon that benefit, half of a parent's benefit who then becomes disabled, and 75% of a parent's benefit if the parent has worked and passed away. So it's important to know that two things. First, that an individual to qualify has to have a disability that started before the age of 22, but that doesn't mean they have to start collecting the benefit before 22. Somebody could apply at age 50, and as long as they had medical records demonstrating that their disability began earlier, then they would be eligible. One other really critical thing is that receiving half or 75% of a parent's benefit does not reduce the parent's benefit. So it's just in addition to whatever the parent is receiving. And then lastly, and really critically, once an individual is receiving SSDI for 2 years, that individual will receive Medicare, which is a critical source of health insurance that can provide a significant level of support through health insurance to individuals with disabilities who, as we know, often have high health care needs. And so to the extent that you can take somebody out of the private insurance market and insure through Medicare, that's a big benefit. So let's apply what we've learned. Mark is 24 and has epilepsy, diagnosed at birth. Mark's dad retired and began receiving a monthly benefit of $2,000 a month. So Mark is eligible for this Disabled Adult Child Benefit because he had a disability that started before the age of 22, and his dad retired and started drawing on his benefit, so he gets half of his dad's benefit, and his dad still gets the $2,000 a month. So now I want to flag for those individuals that say, you know what, I was able to work, or I wasn't able to work previously, but I received a benefit through a parent, as we just went through the example of the Disabled Adult Child Benefit Rule. But now, even though I'm receiving this benefit, I want to try working, but I'm afraid as to what would happen because I don't want to lose the benefit, and I don't want to start working, lose the benefit, and then be without nothing if I'm not able to work in the way that I hope I'm able to. So there's something called a trial work period through Social Security that will allow an individual with a disability to work and begin earning over $1,170 a month while keeping their Social Security benefit for at least 9 months. So that means if you're successful over the full 9-month period of working, being competitively employed, then you'll keep that benefit for those 9 months, and then it will drop away. And it's okay that the benefit has stopped because you're working and you're earning enough that you don't need the benefit, presumably. Now, if an individual is realizing that they're not earning enough or that they're not able to maintain the same level of competitive employment, then within 3 years of having dropped off of SSDI, the individual's benefit will start immediately again without having to reapply within a 3-year period. So that's really beneficial to people who don't want to go through the hassle of resubmitting an application. And after that 3-year period, the individual can still receive Social Security again, but again, they just have to reapply. And now remember that if somebody's received SSDI for 2 years, they are eligible for Medicare. So someone might say, well, if I lose my SSDI, I lose my Medicare. And you just said that was a great benefit to have, and it is. And you can maintain your Medicare for 93 months, which is about 7 years, as an entitlement. And after that, you can continue to receive Medicare after that 7-year period. You just have to start paying a premium. So I think the trial work period, I mention it because I want people to know that it's possible to receive a public benefit and then re-enter the workforce if that's something that you're able to and want to do, without worrying that there's not going to be some sort of safety net. And I think it's a nice peace of mind because I think people should be able to dream and pursue what they want to pursue without fear of what the consequences of that may be. So we just talked a little bit about Medicare, and I want to take a moment to distinguish Medicare from Medicaid, because I'm going to start talking about Medicaid, the second on my slide, for the rest of the presentation until we get to trust and able accounts. But people often think these are the same thing. And I can't blame them. They're so close in the way it's spelled, and they are similar in certain senses, but there's a critical manner in which Medicare and Medicaid differ. So Medicare and Medicaid are both sources of health insurance. Medicare is a source of health insurance for people with disabilities, again, those that have disabilities and have received Social Security Disability Insurance, SSDI, for 2 years, and individuals 65 and over. So usually people think, oh, I can't receive that until I'm 65. Well, that's not true because there's this other doorway, which we've talked about, to get to Medicare. So like SSDI, Medicare is an entitlement. So that means it doesn't have income limits, it doesn't have asset limits, it doesn't matter how much money you have, you qualify for this if you're over 65 or if you have a disability. And one of the benefits is that there's a wide network of providers. So it's a nice portal into different offices and different services that an individual with a disability may need, especially if there's some specialist services that are needed. So Medicaid is also a source of health insurance, and it's typically for low-income individuals and families. So there's different programs through Medicaid. So people may have heard, oh, Husky A, Husky C, Husky D. Primarily speaking, Husky A, Husky C, and Husky D all offer the same coverage. They all offer the same basic health insurance services. But the way they differ is just who they serve. So Husky A, for example, is for parents, caregivers, and pregnant women. Husky C, we're going to focus on principally because that's for individuals who are elderly or who have disabilities. And Husky D is for low-income adults. So the first thing I want to show you is, on my next slide, a bit of an overview of different services that no matter what type of Husky insurance somebody receives, they have certain services that are available to them. And then later on, I'll talk about services that are specific to people with disabilities through Husky C. So to kind of recap here, Medicare is solely a source of health insurance. Medicaid is also a source of health insurance for people that meet low income limits and fall into certain categories. But beyond that, Medicaid provides supports and services for people with disabilities based upon the needs that they have. Some people say to me, well, which should I have, Medicare or Medicaid, or I have this private health insurance. You can have Medicare, Medicaid, and a private health insurance. And in fact, if you can have multiple insurances, ultimately, it's oftentimes a benefit because you're diversifying what's available to the individual. So I just want to show you this little snapshot of a grid. So if people have Husky A, Husky C, or Husky D, there's this manual, and I've given you the link to the manual, of all of these covered services just because you have Medicaid. And I snippeted out this home health care page because a lot of people, as I go through more of the Medicaid programs, you're going to, don't become frustrated with me. You can become frustrated with the system, though, as I am, that there's long waiting lists for many programs out there. And so a lot of my clients, a lot of individuals I come across are on waiting lists for these programs, and they have an intense service need that is not being addressed. And so if that individual has any form of Medicaid, I tell them there are these services. So for example, you can have a home health aide come to your home and provide services 14 hours a week without needing prior authorization, which means without needing a doctor's approval. So if you find a home health agency in your area that accepts Medicaid, you're eligible to receive these things because that's part of your insurance coverage through Medicaid. Now, there are often individuals that need more than that. I have a lot of clients that are underserved, and so I tell them, go to your doctor and get a prescription that says that you need whatever the individual needs, and bring that to the home health care agency so that it will, and so that the state, the Department of Social Services, can approve this additional need based upon the doctor's prescription. So the prior authorization required is a doctor saying that you need more than what is the base minimum allowed without asking for permission, which you see here for a home health aide is 14 hours a week. But I encourage you to visit that, the benefit grid and the guidebook to see what's out there that somebody with Medicaid might qualify for that they just don't know about. One other thing that I want to touch briefly upon, and I think you'll see why it's so brief in a moment, is Community First Choice. And this is one of those programs that is available to anybody who's enrolled in Husky A, C, or D. And basically what it is a program whereby, which was really a function of the Affordable Care Act, whereby an individual, the state will come and assess somebody who has a level of need for assistance with activities of daily living. So this person will need help with, let's say, dressing, bathing, personal care needs. And in assessing this person, the state will give you a budget. So let's say, for example, you have a high level of need, you need total assistance. The state might say, okay, you get $65,000 a year, and you can use that to hire anybody you want, essentially, except for spouses and people with legal obligations to care for the individual, such as a guardian or a conservator. And that person can provide care, and they will be paid from that budget that was allocated to the person. So I say I'm going to spend a cursory amount of time on this because I have a client who applied for Community First Choice in November of 2016, so that's 1 year ago. And I called the state yesterday because they haven't been assessed yet to see whether or not they have a budget. And when I spoke with the individual on the phone, I thought she was going to say, oh my gosh, I'm so sorry, this application fell through the cracks. But what she instead said was, we are so behind in this program that right now we're processing applications from July 2016. So because it was a new program a couple of years ago, the state never really got its ducks in a row in terms of how to meet this outpouring of need, which was unanticipated and certainly speaks in general to the level of need and the amount of people who are underserved within our state. But this program is not being managed in the efficient way that everyone had hoped. So I put the link here and I say, nonetheless, apply. Apply if you have Medicaid and you have a need for assistance with activities of daily living, typically 3 or more activities of daily living, and submit the application. It might be a couple of years before your name comes up, but at least you got in line. I always tell individuals, get in line. At least you're in line, even if you're not getting something today. Something in 2 years is better than nothing in 2 years. So let's throw your hat in any ring that you see. So next, we just talked about Husky A, Husky C, and Husky D. I'm talking about Husky C now because that is the Medicaid program that provides those services for individuals with disabilities. So again, we've talked about the definition of a disability, meaning it's impacting, a medical impairment impacting your ability to work. And there's asset and income limits here. So an asset limit of $1,600 and an income limit of $2,205. So again, when you see these eligibility limits, remember that we can use planning tools like trusts to meet these limits. But I also wanted to let you know that just as with SSDI, when I noted that trial work period, there's also a way that you can get Medicaid services and work and earn up to $75,000 a year and have $10,000 in a bank account and retirement accounts of any value without the need for a trust and still qualify for this program. So I just wanted to flag that in case anybody is out there thinking they can't apply for Medicaid and earn a lot of money. With either way, you can earn as much money or have as much in the bank as you need and use a trust to qualify. But my point here is that there's a way that you can have higher limits without having to use a trust. So there's different Medicaid programs through Husky C. They're known as Medicaid waivers, and waiver is a confusing word. And I just say, well, you're waiving the fact that you're not receiving any sort of care or support within an institutional setting like a skilled nursing facility, but rather you are waiving receipt of care in an institutional setting in favor of receiving it in a community-based or home setting. So there's 3 types of waivers that I want to note for you, and all of these programs have waiting lists, so I want to note that for you. But nonetheless, throw your hat in the ring. There's the personal care assistant waiver, so that's somebody that needs help with their activities of daily living, and it's typically hands-on support with things like dressing, bathing, eating, transferring. And then there's the Katie Beckett waiver, which is available to individuals who up to the age of 21 who can apply prior to 21, and it's typically for people with intense medical needs. So there's nursing support that individuals can receive under this waiver. And then there are DDS waivers for individuals with intellectual disabilities. And I'm in the next slide going to talk about the eligibility for DDS because it's a little different, because you also have to not only meet the low financial rules for Medicaid, but also you have to show that you have an intellectual disability. Whereas for a personal care assistant waiver, the Katie Beckett waiver, you don't have to demonstrate these different disability needs to qualify for the waiver. One other thing I do want to mention though, so I said, okay, there's a waiting list for the personal care waiver and the Katie Beckett waiver. If you know somebody that is in a skilled nursing facility and they've been there for at least 3 months and they're transitioning out, there's a program called Money Follows the Person, and that program basically helps somebody to skip the waiting list. So I mention that because sometimes people are in that scenario where they're transitioning out, and I want them to know, don't come out if you need services until you've put everything in place to get these waiver supports, because otherwise once you come out after that 90-day stay, you're not going to get these supports. You're going to have to get on a waiting list. So let's talk about what Medicaid services or what DDS services are. So in order to be eligible for DDS, somebody has to have an IQ of 69 or lower and a need for assistance with activities of daily living. So if an individual meets that basic definition, they've applied to the Department of Developmental Services, or DDS, they meet that definition, automatically they have access to helpline supports, which basically means there's family grants that are available. Say, for example, a $4,500 grant to have some caregivers in the home. There's respite supports available to give family caregivers a bit of a break. All of these helpline supports are accessed through calling a helpline number and are, unfortunately, again, don't be mad at me, unfortunately are subject to the state budget and what's available, but they do their best to diversify what's available to meet the needs of those individuals that are calling. Then through DDS, an individual can be eligible for employment support, such as a job coach, some transportation, or a day program if an individual is not able to work, and residential supports, meaning help within an individual's home. And once again, these services are based on a level of need and the budgetary availability, but as you may see in the papers, there's a big push right now, and maybe you're even part of it, for individuals with disabilities to be fully funded so that these supports, we can actually put them into place. So here's my transitional slide where I want to tell you that Laura is 18 years old. She has epilepsy. She has a disability, and she has income of $735 a month, and she has $5,000 in a bank account. She applies for Medicaid because she needs some supports and services. She needs some help. She wants some home health services. Her Medicaid application is denied because she has assets over $1,600. So how do we save the day but through a special needs trust? So generally speaking, a special needs trust is my good friend Harry Potter is here. Hopefully you're familiar with him. He's putting on an invisibility cloak. So essentially, a special needs trust is an invisibility cloak. It's something that you can put over money. You can throw it over income, you can throw it over assets, and you can make them invisible for the purposes of meeting the eligibility criteria for SSI and for Medicaid. So there's generally two types of special needs trusts. There's a third type that I'm not going to talk about, and it typically applies to people that are 65 and older, called a pooled trust. So for now, I'm going to focus on a first-party special needs trust and a third-party special needs or supplemental needs. The words are interchangeable, trust. So a first-party special needs trust, I think it's important to say, well, who's the first party? In my example, we just talked about how Laura had $5,000 in a bank account. So that's Laura's money. It belongs to her. Similarly, if Laura received an inheritance from a grandparent and that was sitting in an account, or if there were a settlement that she was the recipient of, all of those examples are money that belongs to Laura. So Laura is the first party. In a first party trust, we're talking about the person who has a disability and it's their money. So a first party special needs trust can be created by that person with a disability if they have the capacity to do so, by a parent, a grandparent, or a court. Trust can be established inside a court or outside of a court, depending on the circumstances. Sometimes there's not a choice, but that's an important thing to know, is that sometimes the court can have oversight over how the trust is being used, and other times the trust, or rather the court, doesn't have oversight over the trust, meaning you don't have to tell the court how the money is being used. So we talked about the funding source. Laura's money is going into the trust. And now, why does the trust work, or how does it work? Well, the idea is that Laura has a wall between herself and the money in the trust, and that wall is a trustee. The trustee can be a family member, or it can be, for example, our law firm is the trustee of special needs trusts. Sometimes people say, can we use a bank or some sort of institutional trustee? Yes, you can, but I always caution people against that with special needs trusts because, as I mentioned before, there's special rules with things like SSI and other benefits that you don't want to negatively impact a benefit by using the trust incorrectly. So the trustee has power to make sole, absolute decisions as to how the money is used. But the money always has to be used for the sole benefit of someone with a disability. So if Laura says that she wants to go buy a Ferrari with the money in her trust, her trustee might say, no, I don't think that's the best use of your money. And Laura doesn't have the right to challenge the trustee because the trustee has sole authority to say yes or no as to how the money is used. So with a first-party special needs trust, there's something called a payback. So that means if there's anything left in that trust when Laura passes away, the state will be paid back first from any money left in the trust for supports that it provided. Well, let's say there's nothing left in the trust when Laura dies, then the state's not paid back. Let's say there's a good amount left in the trust, the state's paid back for the supports it's provided, then the trust can name other beneficiaries like family members to receive the money. So in this case, we're going back to a prior example. Grace is 18. She has a disability. She has $5,000 in a trust now as opposed to a checking account. She applies for SSI, and we have a different result. Her application is now granted because she has resources less than the Medicaid amount and less than the Social Security amount because her extra money is invisible because it's in a trust. So now a third-party special needs trust operates in really the same way as a first-party trust. And what I mean by that is there's still a trustee who can't be that person with a disability. That trustee still has the ability to say yes or no to distributions. The person with a disability is still the beneficiary of the trust, meaning the trust has to in some way benefit that person with a disability. There's a little bit of a looser standard here, meaning if other people benefit too, that's okay. And this trust, however, is distinct in that it has to be created by anybody except the person with a disability, and the money in the trust has to come from anybody except the person with a disability. So when we talk about third-party special needs trusts, we're usually talking about estate planning. So we're talking about parents or grandparents who are planning on leaving money to somebody with a disability. We want to make sure that money passes properly to a third-party trust, because if the money passes properly to a third-party trust, there's no impact on an individual's public benefits. And similarly, let's say that Laura, for example, passes away and there's still money in the trust. Well, with a third-party trust, there's no payback, meaning money will go to other named individuals right away as opposed to the state. So, for example, Leah is 40 and she's receiving SSI and Medicaid, so we know she has to abide by low financial limits. Leah's mom has $100,000, and Leah's mom's will says 100% of my estate to Leah. So when Leah's mom dies, Leah loses her benefits because she now has money and she's over the limits for her programs. Now, can Leah figure it out and get back on benefits? Of course she can. She can put the money in a first-party trust because now it's hers. But if Leah dies 5 days later, now we have to pay the state back. And if the money rather were properly directed to a third-party trust, and Leah's mom's will said 100% of my estate to the trustee of Leah's trust, then when Leah's mom dies, Leah does not lose her benefits because the money is protected and invisible. And when Leah dies, the state doesn't get any of the money left in the trust. So now the last thing that I wanted to talk about is an ABLE account. An ABLE account in many ways is like a hybrid of a first-party trust and a third-party trust. It shares features of both. So the first most important feature that it shares is that funds in an ABLE account are invisible for Social Security, Supplemental Security Income, Medicaid, and other public benefits. So that's the power of it. Just like a special needs trust, you throw an invisibility cloak on. Now, this account is operated by a state's Department of Treasury. So that means that the state where the account is established is the one that's really controlling the investment and how the money in the account is held, as opposed to you as a trustee going to TD Bank or going to Merrill Lynch and setting up a trust account. because with a trust, you can really set it up at any financial institution that you so desire. So Connecticut doesn't have an ABLE program, but that doesn't matter because there are all of these states in blue that do have ABLE account programs, and with the advent of online banking, you can create an online bank account in any state that allows Connecticut residents to establish an account within their system. So I've given you the link to compare and see what states have ABLE accounts. So an ABLE account, the rules are that anybody can contribute to it. So just like this is how we are making a hybrid of our first and third-party trusts. So Leah can contribute to the ABLE account with her money, and Leah's mom can contribute to the ABLE account as well. But the total contributions from all sources cannot be over $14,000 in every given year. The money in the account, like a 529 account or a college savings account, grows income tax-free, so that's a benefit. And the funds in the account have to be used for qualified disability expenses. So that means any expenses related to Leah's disability, which is pretty broadly construed actually. The regulations say if somebody has autism and they need a cell phone to be safe, that cell phone bill is a disability expense. So the most critical thing here is that this includes rent. So remember, I told you to tuck an example into the pockets of your mind, which is that Grace lives at home with her parents, but now we've created a rental agreement under which she pays room and board. Where does she pay the room and board from but her ABLE account? So she's put money in an ABLE account, and she's allowed to pay for her room and board and her food from the ABLE account. Let's say Grace had a first-party trust and was paying for her room and board from the trust. That's not going to fly with Social Security because they don't let you pay for room and board from a trust. They're going to reduce that benefit. So an ABLE account plus a rental agreement help us to make sure somebody can pay fair market value rent for where they're living in their family home, for example, and still be able to qualify for their benefits. The last really critical aspect of an ABLE account, it stands for Achieving a Better Life Experience. And people, the genesis of these accounts was really wanting individuals with disabilities to be able to access and control their money, hold it in hand, for example. So if somebody with a disability withdraws money directly from an ABLE account, they can control the money. Whereas with a trust, as we said, that trustee stands as the gatekeeper between the individual and their money, so they're not able to control it in the same way. So ABLE accounts were created to resolve that issue and to give individuals with disabilities the autonomy and independence that they really need. So that brings me to the conclusion of this presentation, and I am very happy to answer any questions that may have arisen.
Thank you, Kathleen. And while we're waiting for some possible questions to pop up, I did just want to say thank you, and I know that you certainly clarified some things for me. This is not easy stuff to understand, and you did it in a way that was very clear and concise, and I appreciate it, and I'm sure everybody else did as well.
Oh, good. Well, thank you. I'm glad. Like I said, if I can't see people's faces, I either hit it or I missed it, so I'm glad that that was helpful.
Okay, so it looks like we have one question here. And it is saying, so a person can't have a third-party special needs trust and an ABLE account? That's the question.
You certainly can. So somebody could have all three. Somebody could have a first-party trust, a third-party trust, and an ABLE account. And there's a lot of reasons, depending on the factual circumstances, that you would want both. So for example, it's best if somebody has a third-party trust. That's good because, as we talked about, the beneficiaries of that trust, it's never going to be the state. One thing I didn't mention inadvertently is that there is a payback in the ABLE account as well. So sometimes you don't want to build up a lot of money in that ABLE account if there's going to be a payback if anything is left. An ABLE account, once again, can be contributed to by an individual with a disability or other people. whereas that individual with a disability can't contribute to the third-party trust. So it might be, let's say, that a parent has established a third-party trust and has funded that trust either during their lifetime or through their estate planning documents, and the individual has an ABLE account with just their money in it. So the ABLE account has the flexibility to hold that individual's money and the money of other people. There's also other reasons why you might need more than one of these tools. So sometimes people say, well, what should I have, a first-party trust or an ABLE account? And I say, well, how much money are we talking? And they might say, oh, well, I received a $50,000 settlement. And I said, well, you can't put the full amount in an ABLE account because you can only put in $14,000 a year. So there's different factual circumstances as to why you might need 1, 2, or 3 of these planning tools.
Okay, another question for Katie Beckett waiver. What if we get in line and we get off of Medicaid by the time that we are up?
So you have to, at the time that you are enrolled in the waiver, be eligible for Medicaid because, as I mentioned, Husky C is the doorway into these programs. So it's a question of when your spot comes up on the waiting list, then you can become Medicaid eligible at that time. And if you have a disability, then we're really just talking about restructuring whatever money you have by using trusts. So it's not as if you're going to put yourself in a position where we can't make an individual eligible without spending all their money. Rather, if somebody's amassed money in an account or they're making income, then we can just use trust to meet the eligibility rules for Medicaid.
Okay. And is it best to start these ABLE accounts and third-party trust accounts closer to when a child turns 18?
So I'll separate them a little bit. So with regard to an ABLE account, that should be set up when somebody has a disability determination. So typically it's when Social Security has either you've gotten the letter saying that an individual is eligible. So that would be probably around 18. When that person is applying for the ABLE account, and that if the individual is applying for the ABLE account before they have that disability determination, that there's another doctor's form that can be filled out that says that they have a disability. So that's why you can certainly establish an ABLE account before 18, before you've gotten that Social Security letter, but you want to make sure that you have that doctor's letter with the proper documentation stating that there's a disability. And if that's something that you would like, please feel free to reach out to me because there's a form letter that the IRS really recognizes. A third-party trust, I always say it's part of whomever is planning on funding the trust. Let's say it's a parent, to do that as soon as you can as part of your estate plan, because, you know, we never know what the future holds for any of us, sick or not. We could all, you know, pass suddenly. So if you don't have that trust established and your child either is on benefits now or you expect that they might need public benefits in the future, if you haven't created that trust, then the money is going to belong to that child. It's going to be part of their estate. And as in one of my examples, if they're already receiving benefits, they're going to have an eligibility issue. Even if they're not receiving benefits yet, that money ultimately for them to be eligible has to now go in a first-party trust, which has a payback. So the best case scenario would be early planning, having that third-party trust as an empty bucket ready for your estate to fill it up if and when you pass away. And so then everything is seamless and we're not worried about the state controlling any money, and we're not worried about somebody getting kicked off of or being ineligible for benefits.
Okay, and it looks like we have one more here. Okay, if a minor child has money in his or her name now that may exceed income limits, is it best to get all the money out of their name by establishing a special needs trust now? And is there a look-back period?
There's no look-back period for establishing a first-party trust because the individual is not transferring the money, meaning that they are, by setting up a trust, they still continue to, the money is still for them. It's not as if they've given their money away for somebody else. So let's say that child is applying for Medicaid and they have $50,000 in an account, and the parents say, we're going to just have you gift that money to your brother or sister. That would be a problem because now they're giving the money away, whereas setting up a trust is not a transfer and would protect the money. So yes, that's typically what I recommend. So if I have somebody that I know is applying for disability benefits and I see that they have money in their name, they have to set up some sort of trust account or an ABLE account in order to make that money invisible. Otherwise, they're going to be financially ineligible for the benefit and the application will be denied.
Okay, and there's a second part to this question, which is asking what are some good practices that can be done now when a child is 10 to increase chances of qualifying for benefits? And any specific advice for anyone who may bequeath money onto a minor or disabled child?
That's a good question. So my advice would be to see a disability planning attorney. And it doesn't necessarily have to be me, but if it's not me, make sure that whomever it is, you vet who they are and make sure that they have a focus and a practice in special needs, because not every attorney that does elder law, for example, or does estate planning focuses on disability. So there's some attorneys that just might not know the nuances and the rules because they don't play in this sandbox every day. So that would be my first recommendation, is to see an attorney, because what the planning tools for you are different than the planning tools for somebody else. It really depends on what the estate is that we're talking about. What is the money? What is the nature of the money? Is it real property? How much is it? Because there are different planning strategies perhaps that we can invoke in order to plan for that child's future. And then my next recommendation would be that in doing any sort of planning for somebody with a disability, it's important to look up a generation and to look down a generation. So I know it gets a little bit weird with regard to what children might receive from their parents in a will, and there's always this air of mystery and nobody wants to ask and nobody wants to tell. But it's important when you have somebody with a disability, you don't want to be surprised that your mother, when she passed away, decided to leave money to your son or daughter. So what I do within my office is I always ask, you know, who are these individuals within your family? Who's alive? Who do you think would want to contribute to your child financially? And then you can prepare, basically what I do is I prepare a letter that then that parent can give to their estate planning attorney that says that any distribution for this child with a disability should go to the trust for them as opposed to them outright. I think it's also important to know that people, as I talk about a third-party trust being part of an estate plan, more than one third party can fund one trust. So let's say you have a parent and a grandparent. The parent can establish the trust, and the grandparent can contribute to that trust in addition to the parent, in addition to a neighbor. So a trust can be funded from multiple sources, or the grandparent can create a third-party trust and the parent can create a third-party trust. It just depends on what makes sense for that family. Sometimes one trust makes the most sense. Sometimes 2 or 3 trusts make sense. And it's typically when we start talking about who gets the money after that individual with a disability dies. Those remainder beneficiaries might be different. So my recommendation would be planning early is always going to work toward your advantage because there's going to be no undue surprises. Plan with somebody that has knowledge in this area specifically, and make your planning incorporate it amongst individuals in your family, and be willing and open to have a conversation about what your child's needs are and what planning steps need to be taken among the entire family to make sure that those needs are met.
Okay, and one more here. My child is 3 years old, so we are still not sure if she will be disabled or not, or not sure if she will be disabled or not, and we also have 2 other typical children. Does it still make sense to set up a third-party special needs trust?
Yes, I think it does, because it's like a just-in-case type of thing, and there's also some nuances in terms of trust language. So it's possible to achieve the same goal of a special needs trust without calling it a special needs trust. So there's something, for example, called a discretionary trust, and it walks and talks just like a special needs trust in that the trustee has sole discretion to say yes or no. The state doesn't get any payback, and the person's, if that your child needs benefits in the future, the money is protected. So in that way, you've protected the money, but you haven't called it a special needs trust if you don't want to have the special needs trust, a disability kind of category on that trust. Similarly, a third-party special needs trust can be revocable, meaning that parents can set one up and then amend it later on, so, or revoke it later on. So if it turns out that your child doesn't need it, then you can shift your planning a little bit. I think it's really good that you are your child is so young and you're in this position, because you really have the opportunity to plan, and to plan early, and to plan well. And so by planning and being cognizant of your child's potential disability now, early on in their life, you're only going to make them better positioned down the road when they may or may not need benefits.
Okay. If there are no further questions, we'll say thank you once again to Kathleen for taking the time to do this very clear and just all-encompassing webinar for us here on special planning. If any of you listening still have any specific questions that you would like to see covered in further webinars perhaps this coming year, let us know. As always, our webinars are recorded and will be provided on our website, which is epilepsyct.com, where you can register to listen to it again, even if perhaps you want to look up one of the links that Kathleen shared today. Mm-hmm. So thank you, everyone.
I'll just chime in, Monica, as well. If anybody has any other questions that kind of pop up, or you want to reach out to me specifically, my email is kathleen@disabilityplanningpartners.com, and our phone number is 860-238-0031.
Thank you for that, Kathleen, and just for your availability to our clients here at the Epilepsy Foundation. We appreciate it.
Oh, it's my pleasure. Thank you very much for having me.
Goodbye, everyone.
Bye. Thank you.